All right. So we should be now ready to get underway. I need to do one thing very quickly here. Okay. Welcome to what we are calling the Corona Cancellations Moot Court Competition. My name is Cheryl Anderson. I'm a professor of law here at the law school, as well as the director of moot court programs. And I'm here today with our teams and our judges who are going to do a oral argument round in this substitute competition that we've put together as a result of having some of our national competitions cancel while our students were in the midst of putting together their oral arguments. And this, of course, was the result of the COVID-19 pandemic situation. We decided to do this unique event because we wanted to give those teams an opportunity to make the arguments they had been practicing so hard to get ready. And also, this is an opportunity to demonstrate for our first-year students and possibly some of our prospective students what an oral argument is, so that our first-year students in particular can help them use this to get ready for the lawyering skills arguments that are coming up in a couple of weeks. We've also invited family members of the advocates to watch. And so if you are part of the audience, we welcome you as well. We hope this is a one-time only event, but we're living in extraordinary times and we all have to find ways to do things that are different than we've ever done before. So what I want to do very quickly is give you some perspective on what a moot court competition is and what you're going to see. And then I'm going to formally start the round and let the judges and the advocates take over. So quick background then on moot court. It starts when students receive a hypothetical case on appeal. Typically, it's an appeal that goes to the United States Supreme Court. In teams, the students then write a brief on this hypothetical case and submit it, which receives a score. They then begin practicing for an oral argument portion of the competition, in which they will travel to another school or to a court in another city to compete against schools from teams all over the country. Usually they'll have 2 or 3 what we call preliminary rounds, in which they argue at times one side or the other side of an argument. After the end of those rounds, we do what's called a cut, and the top teams advance to an elimination tournament, which is very similar to something like, for example, a basketball tournament, like the NCAA Sweet 16, where you have quarterfinals, semifinals, and then finally a champion team is announced at the end of a final round. As I mentioned, it's part of this system that you have to show well-rounded advocacy, and so the teams will be asked to argue on both sides of the issue at various times. What you're going to see today are 4 arguments. We actually have what we call a swing, which means that one person has to argue both sides because it's a 3-person team and we have 4 arguments. So we are going to have about 15 minutes per person for the arguments. We have 2 judges, and I'll let the moderators, who I'm about to assign here as moderators, tell you who those judges are. And I'm about to do what's called, I'm going to be the bailiff, which is the person who controls the court. So I'm going to call it to order, and I'm also going to be timing their competition. So you'll see me put up time cards. Beyond that, I think that we're ready to go. And so we'll just sit back and enjoy some good advocacy, I hope. Okay, so let me get back here. And we're going to therefore start. This is the formal way that a court session starts. We start, oyez, oyez, oyez. All those having business before this honorable court draw near, and they shall be heard. The Honorable Judges Tim Geiger with Chief Justice Phil Gilbert presiding. God save the United States and this honorable court. Now, ordinarily, I would have asked the court to rise and everybody to be seated after that, but it's the Zoom court, so we're all seated already. With that, I'm going to turn it over to Chief Justice Gilbert, and we will go from there.
Good morning, counsel. Could everybody hear me okay?
Yes.
Yes, Your Honor.
Okay. Will the council please identify themselves and who they are representing in this cause?
My name is Chase Rich, and I will be representing both the petitioner and the respondent.
Well, who is the petitioner in this case?
The petitioner are the state of Setonia and officers Chip Henderson and Mia Jordan.
Okay.
My name is Joshua Colonese, and I'm going to be representing Officer Chip Henderson and Mia Jordan.
Antonella Santee for respondent Bradley Jackson.
Okay. Is the party or the council ready to present their argument?
Yes, Your Honor.
Okay. You may proceed.
Chief Justice, Justices, may it please the court. My name is Chase Rich, and I, along with co-counsel Joshua Colonese, represent the petitioners, the state of Setonia and officers Chip Henderson and Mia Jordan. At this time, we request that 2 minutes be reserved for rebuttal.
Granted.
Your Honors, during my co-counsel's time before the court, he will discuss why the 14th Circuit Court of Appeals erred in holding that the respondent was seized under the Fourth Amendment, even though his freedom of movement was not terminated. During my time before the court, I will argue that the Supreme Court of Setonia incorrectly held that there was no reasonable suspicion for officers to stop the respondent's vehicle when the officer knew that the registered owner of the vehicle had a revoked driver's license. Accordingly, I will request that this court reverse the decision of the Supreme Court of Setonia, resulting in the denial of the respondent's motion to suppress. Your Honors, the Supreme Court of Setonia erred in its holding for 2 reasons. First, it's entirely reasonable for an officer to assume that the registered owner of a vehicle would be the one driving it. Second, a substantial amount of federal and state precedents have allowed officers to make this kind of stop in some capacity. In Terry versus Ohio, this court held that a law enforcement officer may briefly stop and detain an individual without a warrant when the officer has an articulable and reasonable suspicion that is based in fact that the detained person is committing, has committed, or is about to commit a crime. In United States versus Arvizu, this court also noted that it has purposely avoided creating a bright line rule regarding reasonable suspicion and that the reasonable suspicion standard is fluid. However, in this case, when analyzed in a totality of the circumstances, it is clear that it was reasonable for Deputy Ellison to stop the respondent. After running the respondent's license plate, the state database indicated that the owner of the vehicle had a revoked license. While Deputy Ellison did not confirm the identity of the driver before initiating the stop, it is entirely reasonable for an officer to believe that the owner of the vehicle would be the one driving it. This court also expressly noted that police officers may stop a vehicle if the officer has a particularized and articulable basis that a motorist is unlicensed in Delaware versus Prowse. In Illinois versus
Counsel, what specific facts from this case give rise to a reasonable and articulable suspicion that the driver was in fact the registered owner? I mean, common these days is that vehicles will be registered in parents' names or family members' names, and the driver could be any number of people. It's not uncommon for people to loan a vehicle to a friend. What specific facts here gave this police officer that articulable suspicion that Mr. Jackson was in fact behind the wheel of this vehicle?
The specific fact that Deputy Ellison relied on, as reflected in page 3 of the record, was that the respondent was the registered owner of the vehicle and that he had a revoked driver's license. And putting these two together, Deputy Ellison used his common sense and practical considerations of everyday life, which this court has allowed officers to use in both Navarrete versus California and in Illinois versus Wardlow. He made the connection that the registered owner of the vehicle is likely the one driving it. And other courts have allowed officers to make this decision.
Counsel, excuse me. How did the officer know who was driving the vehicle? And all he saw was the feedback from that the registered owner did not have a valid driver's license, but did he know who was driving the vehicle? Did he was able to identify who was driving the vehicle?
No, Your Honor, that is not reflected in the record. However, it was reasonable for Deputy Ellison to make this brief investigatory stop to determine the identity of the driver of the vehicle, to make sure that it was either Mr. Jackson driving the vehicle or that it was someone else lawfully driving the vehicle. Because as this court noted in Delaware versus Prowse, unlicensed drivers are presumably the less safe drivers. So we should defer to officers' training and reasonable judgment to help keep roadways safe by keeping unlicensed individuals off the roadway. And here, this is a brief.
But counsel, why is it not appropriate? Why would it be, or I guess why is the Supreme Court of Setonia's reasoning incorrect? They took the reasoning a step further. They wanted some facts in the record that the officer observed a male of approximately 30 years of age, fitting the physical description of the defendant. If it was just, this vehicle is on the road, there's a person behind it, the person who owns it has a suspended license, that's not reasonable, articulable facts that the defendant was actually behind it, based on many of the things that the Supreme Court of Setonia pointed out, and that I pointed out in my prior question, that people loan cars to each other all the time. Family, the vehicle will be in a parent's name, the children may be driving it. What facts did the officer point to that went beyond just it was registered to Mr. Jackson, who has a suspended license? What are there? Did the officer observe any specifics that the Supreme Court of Setonia said he should have noted before executing this stop?
He did not observe any other additional facts, Your Honor. As reflected on page 3 of the record, the only information that Deputy Ellison relied on in making this stop was the assumption that the registered owner who had a revoked license was the one driving. However, under the Fourth Amendment, this assumption is permissible because it is, one, vehicles on the roadway, as this court has noted in previous past precedent, that vehicles on roadways have a very reduced expectation of privacy, where the Fourth Amendment does not add its paramount interest that it is in someone's home. Also, as under Terry versus Ohio, all an officer needs to make this brief investigatory stop is a reasonable suspicion that a person is committing a crime. And in this case, Deputy Ellison had a particularized and individualized suspicion that Mr. Jackson was in fact committing a crime when he knew that Mr. Jackson had a revoked driver's license and he saw that vehicle being operated on a state of Setonia public roadway.
But counsel, in fact, I mean, the Supreme Court of Setonia said that's not a reasonable, articulable suspicion. If we follow that and determine that we agree with the Supreme Court of Setonia that that is not an articulable or reasonable suspicion, that aside, are there facts in this case that we can point to if we choose to overrule the Supreme Court of Setonia and say, despite this officer's errors and even though his statements don't rise to the level, facts exist to rise to that level? Are there those facts here that we could point to should we choose to decide as you're requesting and overrule the Supreme Court of Setonia?
One fact that this court should consider, and if it decides to overrule the Supreme Court of Setonia, Your Honor, is the fact that Mr. Jackson was a repeat offender. He was charged as a habitual offender under the state of Setonia law, which requires that this be his third or subsequent time driving with a revoked license. And in fact, as reflected in the record, 2 days after this incident with Deputy Ellison, he was again seen driving his vehicle again without a license when he encountered officers Henderson and Jordan. So it is clear that the respondent has flagrantly violated the laws of the state of Setonia, requiring somebody have a valid driver's license to operate a vehicle. And that is something that this court should defer to as well in an officer's reasonable judgment and training in helping stop these repeat offenders from frequently violating the laws of the state that they are in. And also, Your Honor, this is unlike the suspicionless stops that this court rejected in Delaware versus Prowse. In Prowse, the officer there testified that his sole reason for stopping the defendant was to check the license and registration of the driver. However, that case was in 1979, long before in-car computers were installed in police vehicles. There, the officer had no suspicion whatsoever to stop the defendant and check his license. Here, Deputy Ellison had a suspicion. He knew that the owner of the respondent's car had a revoked license. He knew that the vehicle was being driven on a Setonia public road, and he knew that it was illegal for someone to drive with a revoked driver's license. Putting these facts together, he had a particular and reasonable basis for assuming that the respondent's vehicle was being operated illegally. Because of this, he had a reasonable suspicion to stop the respondent and confirm the identity of the driver.
But counsel, again, I don't mean to keep pressing this point, but it sounds a lot like, at least to this to me as a judge on this court, that what you're advocating and what the officer did in this case is to an extent he presumed that the person behind the wheel was, based on what he articulated, he presumed that the person behind the wheel of the vehicle was the licensed driver. And as the Supreme Court of Setonia points out in the majority opinion, if Terry teaches us anything, it's that the officers in the court should not presume illegal activity. The presumption should be legal activity, that they have to have something specific they can point to that specifically points to illegal conduct being or happening at the moment. And I'm still troubled by the fact that there doesn't seem to be anything specific and articulable that this officer pointed to, other than just the licensed driver has a suspended license.
Your Honor, while Terry does not allow officers to assume every instance is in fact illegal conduct, however, Terry also does not require that officers give every single action the presumption of innocence. Every single action, an officer does not have to go through mental hoops to determine whether an act is, and any act that someone does is by any means at all legal. An officer can use his common sense and everyday practical considerations of everyday life, as this court has noted in the past in both Navarrete versus California and Illinois versus Wardlow, in putting all of these circumstances together to determine if someone is in fact committing a crime. As you recall, Your Honor, in Terry, the conduct that the defendant in that case was committing by itself did not constitute a crime and was not illegal. However, putting all of the facts together, the officer was able to make the inference that a crime was about to take place. And here, Deputy Ellison was able to use these considerations and inferences to put together that a crime may be being committed, which permitted him to make this brief investigatory stop to determine if a crime was being committed.
Let me ask you this: does the seriousness of the offense factor in as to whether or not there's a reasonable suspicion to stop the vehicle? Does the seriousness of the offense have any bearing on any specific articulable facts that are needed to justify a Terry stop?
Your Honor, they shouldn't in this case. If the officer has a particularized and individual basis that someone is committing a crime, whether it's a petty crime or a felony, that officer does have the lawful authority under the Fourth Amendment to make this brief investigatory stop. And also, Your Honor, several circuits and at least 20 states allow officers to make this kind of stop in some capacity, acting on information gathered from a computer database, and that is all the information they have. For example, the Fifth Circuit has allowed officers to make these brief stops to determine the insurance status of a vehicle whenever a state database could not confirm the insurance of a vehicle and did not have any information suggesting that the motorist was driving uninsured. And also 20 states, 10 state Supreme Courts, and an additional 10 states intermediate appellate courts have allowed officers to make this kind of stop when the officer does not have any information suggesting that the owner is not the one driving. And it is for these reasons, Your Honor, that we respectfully ask that this court reverse the decision of the Supreme Court of Setonia. Thank you.
Thank you, counsel. Next, who's up next?
Chief Justice, Your Honor, and may it please the court. My name is Joshua Colonese, and along with my co-counsel, Chase Rich, we represent the petitioners, officers Chip Henderson and Mia Jordan. In my time before the court, I will assert that the 14th Circuit incorrectly held that Bradley Jackson was seized when he was struck by a bullet because intentional infliction of physical force that results in escape only amounts to an unsuccessful attempt at a Fourth Amendment seizure. Your Honor, the Fourth Amendment protects the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures. Furthermore, when seeking damages under 42 U.S.C. 1983 for excessive force used in violation of the Fourth Amendment, the claimant must demonstrate that a seizure occurred and that that seizure was unreasonable. Here, Your Honor, we have clearly established law that dictates when a seizure has occurred. This court has held in Broward versus County of Inyo that a violation of the Fourth Amendment requires an intentional acquisition of physical control over the suspect. Furthermore,
Counsel, is there any evidence in the record that Officers Henderson and Jordan intended to seize Jackson?
Your Honor, there is nothing specifically in the record that states that they intended to seize Jackson. However, it can be shown by the totality of the circumstances, Your Honor, in which they did approach the vehicle, asked Mr. Bradley Jackson to exit the vehicle and asked him to show him his hands, which at that point, Mr. Bradley Jackson fled the scene, which did lead to the police officers using 13 bullets, 2 of which did make contact with Mr. Jackson in order to stop him. Your Honor, this court has also asserted this point in Brendan versus California, finding that a seizure occurs only when the suspect actually submits or voluntarily or otherwise to the police officer's assertion or force of authority. Your Honor, as petitioner may argue, there is another confusing yet challenging rule for this Fourth Amendment seizure in Hadari D, which states that touch alone on behalf of a police officer without capture would be enough to constitute this seizure. Your Honor, from the time of the founding to the present, the word seizure has meant a taking of possession per Webster American Dictionary. To further this understanding, Black Law's Dictionary also defines a seizure as the act or an instance of taking possession of a person or property by legal right or process. To my first point, Your Honor, the physical force applied here against Jackson does not constitute a seizure because Jackson's freedom of movement was not terminated. He was able to evade the police, evade capture, steal a vehicle, and then drive himself 60 miles to Brooke Hospital despite being shot. In his petition, Your Honor, Jackson essentially argues to broaden the scope of the Fourth Amendment seizure, stating that at any time a suspect is struck by a law enforcement officer, the Fourth Amendment prohibition against unreasonable searches creates a violation, even if the officer's use of force does not result in the suspect stopping or otherwise acquiescing to that officer. Your Honor, Hadari D's line of reasoning really creates a confusion and an issue of clarity when speaking about a Fourth Amendment seizure, because to say that an individual is seized for Fourth Amendment purposes when there is only physical touch by a police officer without actual capture really opens the door to cases where an individual is grabbed but then escapes and can then board a flight to, let's say, Puerto Rico or an island and still be seized as per Fourth Amendment requirements, Your Honor.
But counsel, I mean, that there are a number of circuits that have held that attempting to seize, as long as physical force is applied, is a seizure, even if the suspect escapes or the attempted seizure is unsuccessful. If physical force is applied, then a seizure has taken place. I mean, the Ninth Circuit, the Eighth Circuit, the state of California, the 11th Circuit have all decided consistent with that idea. How do we differentiate being shot? I mean, that being shot at is the ultimate level of physical force. I mean, they can lay hands on, they can, I mean, officers could use a police car to attempt to restrain making contact with a individual. All of those are levels of force. How is being shot not a higher level of force that's attempting to restrain a defendant?
Your Honor, although it is a force, and we're not saying that it is not a force, Your Honor, it just does not meet the narrow standard of capture, which is needed for a Fourth Amendment seizure, Your Honor. It's the clarity aspect that is lacking in Hadari D, which does not create that clear rule that we see in Broward, Your Honor. Here, this is the ability of police officers simply perhaps touching somebody, and these claims are going to be open to bring Fourth Amendment seizures, as I mentioned earlier. It's possible that if Bradley Jackson was shot, but then left and was never seen again, it would still allow for a Fourth Amendment seizure to continue. It would be a continuous seizure, Your Honor, which simply does not exist in Fourth Amendment jurisprudence. There needs to be intentional touch, Your Honor, with the acquisition of physical control by the officer in order for there to be a Fourth Amendment seizure.
So the position you'd like this court to take in overturning the district court then would be that the level of force isn't the level and severity of the amount of force isn't the key thing. It's the level of actual control over the defendant that results.
Yes, Your Honor, and that's what it is. There needs to be capture along with the physical intent for the officer to seize and have control. It's similar, Your Honor, to when an individual is stopped by a police officer and they turn on their siren. It is at that point, Your Honor, when you pull your car over and you have seized your movement to receive the ticket or speak with the officer, that a Fourth Amendment seizure has taken place. Your Honor, although Hadari D came out after Brower and was written by Justice Scalia, does not mean that Brower is overturned or bad law. There is simply nothing to suggest in the opinion that Brower was ever overturned. Your Honor, Brower is still good law, and it presents a narrow, concise definition of what a Fourth Amendment seizure is. Your Honor, Brower presents clearly established law set out by this court, and this court should recognize that law from its opinion that it has set out. This court does not need an amended law or a new law because Brower's opinion is clear, Your Honor. We can see this in the Fifth Circuit in Flores versus City of Palacios in applying Brower's interpretation of a Fourth Amendment seizure, where it was held that a police officer shot at and hit an arrestee's car, which resulted in the arrestee immediately stopping the car, that a Fourth Amendment seizure was created. And to my second point, in determining a 1983 case for excessive force, the second requirement for determining is if the acts were reasonable is considered. So we look towards the reasonableness aspect, Your Honor. And even if this court finds that Bradley Jackson was indeed seized, Your Honor, the reasonable standard for the events that transpired were justified. Your Honor, it was reasonable for officers Chip Henderson and Mia Jordan to shoot at Bradley Jackson 13 times, each bullet representing that intent to stop a fleeing suspect who not only could have hurt the officers themselves when he sped off, but also other potential citizens. Your Honor, Jackson did present a threat to the officers and others, as it was noted in the record at page 4 that he sped off, ran over landscape, hit a vehicle, and continued to proceed to steal another vehicle, to which then he did drive 60 miles to Brooke Hospital. Your Honor, we need to allow police officers who are trained to use their discretion. They were coming upon a hostile environment where it was known that there was a drug ring present. They shouted to Mr. Jackson to show him his hand, standing at the front of the tire and standing at the door of the truck, to which at that point, Mr. Jackson, using this massive metal weaponry in his truck to evade. Your Honor, it's reasonable to believe that these officers could have been struck at that moment. All Mr. Jackson had to do was turn his wheel and drive in that direction. Furthermore, Your Honor, to speak to the totality of the circumstances, it is cited on the record at page 4 that Mr. Jackson actually pled guilty to aggravated assault of a police officer and fleeing, which is a felony. And Your Honor, we're not saying that the shot that Mr. Jackson receives are without remedy. Perhaps this would be more sustainable in tort law or in civil case for a battery where compensatory damages may be awarded. But it simply does not meet the threshold requisite to establish a 1983 case for excessive force and unreasonable response from police officers. Your Honor, the police are trained servants of the law, and we need to entrust these professionals who deal in these matters to use their discretion and act upon the authority that's been given.
So counsel, I mean, on this is backtracking a little bit to the earlier part of your argument. I guess a turning point or a point where there's a kind of a fork in the road for us to take this line of cases is that while I mean, we're all familiar with intent follows the bullet when we're talking about a crime by one citizen against another. Here, you're asking us to find that in a situation like this, where the force may or may not have been justified, but it likely at some level was justified by the police, even though it was their intent to seize him by using the potentially lethal force of firing their weapon, that intent doesn't necessarily just automatically carry through and result in a seizure unless it actually results in the seizure.
Yes, Your Honor. That's exactly what I'm saying. The officers never had capture of Mr. Bradley Jackson. The 13 shots were them trying to get Mr. Bradley Jackson to stop, each shot representing an attempt to bring that cessation of movement on Mr. Bradley Jackson, which never occurred. As I mentioned earlier, he went on to run over landscape, hit vehicles, and drive 60 miles. It wasn't until the very next day, Your Honor, where police apprehended him at Brooks Hospital because a doctor called in mentioning an individual with a bullet wound, that they were actually able to, at that point, seize his mobility and capture and bring him within the hands of the law, so to speak, Your Honor. So it could be established that under the circumstance of this encounter, Your Honor, the officers reasonably believed that Jackson presented a harm to themselves and to the public when he sped off in his vehicle and hit other vehicles, as I mentioned. Your Honor, harmonizing the principles of this court's opinions in Brower, Mendenhall, and Brenneland, the touchstone of a seizure is that there must be some taking of possession of the suspect such that it results in a termination of physical restraint and the suspect's liberty or freedom of movement through the means intentionally applied by police officers. In sum, despite being struck by 2 bullets, Petitioner Bradley Jackson was not seized by officers Henderson and Jordan for purposes of the Fourth Amendment. Under longstanding case law from this court, a shot does not constitute a seizure without physical capture. And here the officers used force, but failed to effectuate an immediate seizure of Mr. Bradley Jackson. And as such, Your Honor, the 14th Circuit improperly found that the officer's action constituted a seizure. And Your Honor, it is that for that reason that we therefore ask that this court reverse and remand the ruling of the 14th Circuit, because to do otherwise would ignore the proper established law that has been created by this court. Thank you.
Thank you, counsel. Antonella?
Sorry, it's Chase who is going to be.
Chase is doing this one? Okay, Chase.
Yes, Your Honor.
Okay, you're back up, Chase.
Yes, sir. Mr. Chief Justice, Justices, may it please the court. My name is Chase Rich, and I, along with co-counsel Antonella Santi, represent the respondent, Mr. Bradley Jackson. During my co-counsel's time before the court, she will discuss why the 14th Circuit Court of Appeals was correct in holding that Mr. Jackson was seized improperly under the Fourth Amendment when he was shot twice by petitioners Henderson and Jordan. During my time before the court, I will argue that the Supreme Court of Setonia was correct in holding that Deputy Ellison did not have reasonable suspicion to stop Mr. Jackson when he did not know the identity of the driver of Mr. Jackson's vehicle. Accordingly,
before we get started, what's the standard of review here for us?
Your Honor, the standard review here would be de novo, and determining whether or not there is reasonable suspicion under the Fourth Amendment, this court reviews such decisions de novo. There are no disputed questions of fact here.
You may proceed.
Your Honors, the Supreme Court of Setonia was correct in its holding for 2 reasons. First, the Fourth Amendment requires that officers make inferences drawn from articulable and particularized facts to create reasonable suspicion and not simply rely on assumptions. Second, a bright line rule stating that reasonable suspicion for minor crimes should not be created from computer database information alone. Time after time, this court has held that the touchstone of the Fourth Amendment is reasonableness. And as most recently stated in Riley versus California, this generally requires that law enforcement officers either have a warrant issued by the judiciary or reasonably rely on a specific exception to the warrant requirement. Here, the issue is whether the officer had reasonable suspicion to stop Mr. Jackson as required by this court in Terry versus Ohio. In Terry, this court held that a law enforcement officer may briefly stop and detain an individual without a warrant when the officer has an articulable and reasonable suspicion based in fact that the detained person is committing, has committed, or is about to commit a crime. Thus, reasonable suspicion requires that an officer be able to point to specific and articulable facts, which taken together with rational inferences from those facts, reasonably warrant that intrusion.
Okay, counsel, isn't the fact that the officer observed and was reported to him through the national computer database or through the dispatcher that the vehicle whose license he had run that the owner had a suspended license and shouldn't be driving on the highway? Isn't that reasonable suspicion to stop under Terry?
No, Your Honor, because anybody could have been driving Mr. Jackson's vehicle. As reflected on the record on page 3, Deputy Ellison merely acted with the assumption that Mr. Jackson was in fact the one driving his vehicle. And an assumption amounts to nothing more than a mere hunch. As was noted by the District Court of the state of Setonia, a person does not commit a crime by simply owning a vehicle and happen to have a revoked license. It is only a crime for the individual with a revoked license to be operating that vehicle. And as such, anybody could have been operating Mr. Jackson's vehicle legally had they been licensed.
Well, that's true, but then the officer would have gone up. If the driver had a valid driver's license, he'd have said thank you and gotten back into his car. There wouldn't have been any problem. But as my colleague has said, you loan vehicles to family members, to friends, but doesn't an officer have the ability under Terry to if he observes a vehicle that is on a public highway where other vehicles are driving, other pedestrians may be, and observes a vehicle, the owner of whose license has been suspended, to stop and check and see who's driving?
No, Your Honor. An officer does not have the authority under Terry to make this kind of stop unless he has an actual, individualized, and particulable basis for the reasonable suspicion to stop that vehicle. The Fourth Amendment prohibits any seizure that is unreasonable, no matter how brief. And even though an investigatory stop, such as the one that you have suggested, Your Honor, may take no longer than a few minutes, it is still an intrusion into the liberty interests of motorists who have committed no crime at all and are simply happen to be driving a vehicle that happens to be owned by someone with a revoked driver's license. And that is a situation that this court should consider. This court should not reward the officer for making a guess and happening to being right. This court should hold all officers to the high standard of the Fourth Amendment to protect the liberty interests of motorists. And Your Honor,
but counsel, even though in Terry we set out the articulable and reasonable suspicion, in Bruce, didn't we carve out a separate, slightly different rule when it came to stopping motorists as opposed to an actual Terry stop? I mean, in Bruce, if I recall, or the majority opinion in that case references that a traffic stop is allowed if the officer has a particularized and objective basis for making the traffic stop. Here, isn't it a particularized and objective, a purely objective basis? I mean, he wasn't assuming anything. This vehicle is registered to Bradley Jackson. Bradley Jackson doesn't have a valid driver's license. That's particularized and objective basis to at least effectuate the stop to ascertain who the driver is it not?
Your Honor, the respondent respectfully disagrees with that contention. While Prowse does allow officers to make these kinds of stops if there is an objective basis that a person is committing a crime or is unlicensed, Prowse also summarily rejected officers to stop vehicles based on hunches when there is no actual facts indicating that a crime is being committed. And here there are no actual facts that were reflected on the record that Deputy Ellison relied upon to infer that Mr. Jackson was committing a crime. And as is noted on the record of page 3, Deputy Ellison acted on the bare assumption that Mr. Jackson was the one in fact driving that vehicle. And in facts analogous to these, the Supreme Court of Kansas rejected the ability of officers to assume such activity in State versus Glover. In that case, Mr. Glover was stopped only on the assumption that he was driving a vehicle with a revoked license. And in that case, the Supreme Court of Kansas held that an assumption has no basis in proof or demonstration, so it is only an inarticulate hunch or an unparticularized suspicion. In this case,
so counsel, I think what you're telling us is that even under Prus and our Vizu, the officer would have needed to testify to something. I got back 96 Ford registered to Bradley Jackson. Bradley Jackson has no valid driver's license. And then he needed to go at least one step further, that Bradley Jackson is a 30-year-old male with long gray hair. And I observed a male of approximately 30 years of age who appeared to have longer hair driving the vehicle. He needed to take that extra step for it to be objective.
yes, Your Honor, we are suggesting that the officers must take that objective next step to make that objective basis. And in fact, several states have allowed officers to make this kind of stop when they have made this extra step. The states of Maine, for example, State versus Tozier, the officer observed the sex of the driver and was able to compare that to the information that he had. And that is similar across several other states, Your Honor. And
if we go that route, counsel, what about in states where relatively dark tinted windows are allowed, or states like the southwestern part of this country where I happen to be from, where the sun is extremely bright and reflects off of windows and you cannot see through, depending on the angle, you would not be able to make out those particularized facts about any particular person in the vehicle. Isn't it safer for us to just say objective is 96 Ford registered to Bradley Jackson. Bradley Jackson has no license. I'm going to make this stop to determine if that driver is Bradley Jackson?
no, Your Honor, because in those cases, officers, even though an officer may not be able to make that extra step to determine reasonable suspicion, that does not simply create reasonable suspicion by the absence of those facts. We should require officers to make the additional observation in some other way. Such as that any of the numerous traffic infractions being committed by somebody on the roadway. But as reflected in the record, Mr. Jackson did not commit a single traffic infraction before being stopped. So it is clear that there was no overriding interest in public safety that would allow officers to make this kind of stop, as the petitioner contends. And this court has noted in United States versus Cortez that the process of finding particularized suspicion is an officer drawing inferences and making deductions from the data that they have. In this case, Deputy Ellison had no data about who the individual driving the car was. All he knew was that the respondent legally owned and registered a vehicle, and which, as reflected on the record by the district court judge, is not a crime. Anyone could have been driving that vehicle, from Mr. Jackson's mother, brother, or friend, or neighborhood, or anybody in his neighborhood could have been behind that wheel. And as the district court judge noted, people often have multiple vehicles registered under their name and allow others to drive them, such as their family members. Because of this, there simply was not reasonable suspicion based off this information alone. And turning to my second point, Your Honor, this court in United States versus Arvizu held that it has deliberately avoided creating a bright line rule for determining reasonable suspicion. Therefore, information from computer databases alone, such as in this case, should not create reasonable suspicion for minor offenses. While computer databases have made modern life, including police work, much more convenient, they are still human creations subject to human error. This was shown in the extreme.
But counsel, this goes back to my earlier point about an objective and particularized basis. Aren't those databases the most objective we can be? I mean, whether Officer Henderson believed the driver to be approximately 30 years of age, that's a subjective determination by an officer, granted made based on training, years of experience, factors like that. But isn't information from a database that gives information, isn't that as objective as the officer could be on determining, should I make a stop here to determine if illegal activity is taking place?
Your Honor, while databases may be a source of objective information, as you have shown, they are still subject to human error. And this was shown in Rothgary versus Gillespie County. In Rothgary, the petitioner was arrested and charged with being a felon in possession of a firearm after a criminal background check disclosed that he had been convicted of a felony. However, he had in fact never been convicted of a felony and the check was erroneous. Because of this,
likewise, counsel, doesn't our system though rely on humans? I mean, for determinations of reasonableness or I guess reasonableness is what we're talking about here. So, I mean, we rely on humans, jurors, to make a decision whether reasonable doubt exists. We rely on grand jurors or judges to make determinations whether probable cause exists. So, I mean, because humans are involved at all of these decision-making levels, that human error is always possible, but it's something that is still part of our objective or reasonable or probable finding. So how does that differ here in simply making a traffic stop to ask for a driver's license to confirm identity, as the Chief Justice had indicated? Had he given him a license, shown he was somebody other than Bradley Jackson, having observed no other illegal activity, the likely result of this stop would have been, thank you for your time, have a good day. And what would have been, I mean, where would have there been a Fourth Amendment violation had that been the ultimate end of this traffic stop?
The Fourth Amendment violation that would have occurred in that case, Your Honor, was the fact that somebody was seized without reasonable suspicion of a crime actually being committed. And while we are all humans and officers' determinations often are subject to this human decision-making, what we're suggesting, Your Honor, is that officers have more than just a bare, uncorroborated fact in making a stop for a crime that is simply not that serious. This is especially true when we look at the crime that the respondent was charged with. He was charged with a misdemeanor in the state of Setonia, which carries a punishment of at least 91 days in jail and a fine of $1,501. Given the relatively low stakes of such a crime, it is not an overwhelming interest of law enforcement officers to act as quickly as possible without corroborating the bare bones information that they have. And therefore, Your Honor, we respectfully ask that this court affirm the ruling of the Supreme Court of Setonia that there was no reasonable suspicion to stop the respondent. Thank you.
Well, one more question, counsel. So you're saying the seriousness of the offense determines whether or not there's a Fourth Amendment violation?
Your Honor, this court should consider the seriousness of the offense in determining if there was a Fourth Amendment violation. And this court has held that in the past in several circumstances. This court has allowed officers to invade the privacy interest of someone's home if they believe that there is a crime being committed inside that home that requires their intervention to save a life, or if, I see my time has expired, Your Honor.
You may finish your answer.
Thank you, Your Honor. And they may also invade may also invade the privacy interest of someone's home if there is a fleeing felon. And in those cases, the seriousness of the crime does allow officers to abrogate some of the protections of the Fourth Amendment. And here we should not allow officers to abrogate the Fourth Amendment based off a relatively minor crime.
Okay.
Thank you, Your Honor.
Thank you, counsel. Okay, now Antonella.
Chief Justice, Justices, and may it please the court. I'm Antonella Santi, and I too represent the respondent, Bradley Jackson. In my time before the court, I will assert that the decision of the 14th Circuit should be affirmed because under the Fourth Amendment, two prongs must be met to establish that Jackson was seized. First, sufficient physical force was established when Jackson was shot twice. And second, there is clear evidence that officers Henderson and Jordan intended to seize Jackson when they both instructed him to stop and fired 13 bullets at him. Your Honors, this case presents a 42 USC 1983 claim for use of excessive force, as petitioner mentioned earlier. And at issue here is whether a Fourth Amendment seizure occurred. This court has defined what constitutes a Fourth Amendment seizure in two distinct leading cases. And the most recent interpretation is set out in California versus Hadari D, where this court broadened the definition of a seizure, indicating a seizure occurs by either one, a laying on of hands, or application of physical force with the intent to restrain, even if ultimately unsuccessful, or 2, submission to the assertion of authority.
Counsel, how do you reconcile then Justice Scalia's opposing decisions in Hadari D and Brower? One requires a seizure to result in a capture, while the other merely force even if the suspect escapes. So is it your position that there does not have to be a physical seizure in order for there to be a seizure? How do you reconcile the two cases?
Your Honor, California versus Hadari D was decided 3 years after Brower, and Justice Scalia did decide both. So it's natural to infer that in Hadari D, Justice Scalia wanted to broaden the definition. And the reason for that, in Hadari D, he mentioned that he wanted to avoid the use of excessive force. And in cases where a suspect is injured and evades capture, it's still considered a seizure, Your Honor, because there was physical contact with the suspect. Now, Hadari D did not overturn Brower, and the second prong under Hadari D includes the definition set out in Brower, which is the submission to authority and cessation of movement. So what Hadari D did was just add that additional prong where it requires physical force by the application of some sort of instrumentality or an actual laying on of hands with the intent to restrain, regardless of escape, Your Honor. To my first point, the bullets that hit Jackson's arm and lower back are sufficient to establish the element of physical force required under Hadari D. And numerous circuits have followed Hadari D's line of reasoning. And with respect to physical force applied by the means of a gun, circuits have reasoned that the bullet striking the suspect is considered the physical force, Your Honors. As the Fifth Circuit in Lytle versus Bexar County, there the court reasoned that the bullet fired at the suspect while he was fleeing was considered the physical force required for a Fourth Amendment seizure. The Eighth Circuit in Moore versus Indahar again reasoned that a bullet striking the suspect constituted the physical force required for a seizure. The 11th Circuit.
Counsel, I guess I'm want to talk a little bit about the first part of the question here, whether there was an actual seizure or not, or whether there was actual physical force applied. The first part of what is necessary to be found for there to be a 1983 claim is that there was excessive, that the force used was excessive. I think we can go round and round about whether being shot at is force, whether being shot is a seizure. But if the force used by the officers was reasonable, or I guess more importantly, wasn't an unreasonable use of force, that ends the inquiry. So why is it unreasonable for officers to use their firearms to attempt to stop a driver who is using their vehicle to essentially assault the police officers? I mean, one of the officers here was in the line of this vehicle when he sped out of the parking space. Is she not allowed to use potentially lethal force to attempt to stop that driver from running into her while she's standing in front of a vehicle?
Your Honor, it is reasonable for an officer to use force when required. However, in this case, as reflected on page 4 of the record, neither of the officers were standing in harm's way of the vehicle at the time that Jackson drove out of the complex. Officer Jordan was standing next to the driver's side tire, and Officer Henderson was standing next to the driver's side window. So they were not in front of the car when Jackson drove out, Your Honor. And to answer your question regarding whether this is excessive force, Your Honor, Officers Henderson and Jordan shot Jackson, or fired their 13 bullets at him, 2 of which struck Jackson. The second bullet that struck Jackson was in his lower back. That means he had already driven out, and his back was to the officers, and the officers.
But counsel, aren't police officers allowed to shoot fleeing suspects if they present a potential danger to the public? If they've exhibited potentially deadly conduct or demonstrate an ongoing threat to the public. I mean, a fleeing suspect who's carrying a weapon, an officer can shoot at that fleeing suspect to attempt to apprehend them, can they not?
Yes, Your Honor. However, here there was no indication that Jackson was armed or dangerous. In fact, as reflected on page 4 of the record, Jackson did not know that the individuals approaching him were law enforcement officers. He thought he was being carjacked and reasonably feared for his life, and that is why he fled the scene. And as reflected on page 4 of the record, you can also see that when Jackson reached the nearby strip mall, he asked citizens on the street to contact the police department because he thought he was being chased by carjackers. And then in desperation, he got into a car and fled to a nearby hospital to receive medical assistance for the injuries he sustained during the shooting, Your Honor. And going back to my point on the excessiveness, 13 bullets, Your Honor, if the officers felt they were in harm's way, they could have shot once or maybe twice. And when Jackson was already out of the complex, they could have gone into their car and pursued Jackson in their vehicle instead of continuing to shoot. Another point to mention, Your Honor, this was a residential area. Anybody could have walked by a child, another adult during this shooting, and they could have injured.
Well, counsel, to a certain degree, don't we have to rely on police officers' training and experience to know when their use of force? Granted, police officers, there are very valid situations where police do use excessive force, do put other citizens in danger. But isn't it one of their primary parts of their training and goals to not do things like that, to where if they're using a level of force at the moment, in the moment, where I guess the presumption is that a police officer is using an appropriate level of force given the circumstances and the surrounding area and safety of all citizens. Yes, there are outliers where officers do go outside those bounds, but here, this is a gentleman in a full-size pickup speeding out of a parking space, driving through as you said, residential parking area, running over landscaping. I mean, he could have ran over a child who ran out into the parking lot. Where do we draw that line on who was the one that was unreasonable here?
Your Honor, yes, the officers do have discretion with regards to the force they use and also to be aware of their surroundings. However, here, as I mentioned earlier, the second bullet that struck Jackson was to his back. So he had already driven out, and the officers could have stopped shooting and again gone into their car and pursued Jackson in his car, and yet they still chose to keep shooting, Your Honors. And with regards to that discretion there, they should have used their reasonable discretion to stop and say, hey, maybe we should stop shooting and actually chase him in the vehicle to prevent him from harming, quote unquote.
To your point,
Counsel, let me ask you this. Let's say the bullets had just hit the truck and not hit Jackson, would you still be arguing that there was a seizure?
Your Honor, under HDRD, there needs to be some sort of contact made with the person of the suspect with either some form of instrumentality, i.e. a gun, or by an actual application of laying on of hands by the police officer. So under HDRD, there is contact that needs to be made, Your Honor, and that's why HDRD wouldn't open the door to anybody requesting that a court determine a Fourth Amendment seizure occurred.
Well, let's say that the bullets smashed the window and the glass in the window injured Jackson. But the bullet didn't strike Jackson, but yet Jackson was injured by flying glass. Would there, in your argument, would there still be a seizure?
Under HDRD, Your Honor, no, because the bullet would need to strike the suspect to constitute a seizure. Now, there are courts, other circuits that have determined some form of touch or instrumentality such as a beanbag propellant that hit the suspect constituted a seizure. Perhaps if that had happened in this case, the glass hitting him, this court could determine that that would constitute a seizure. But specifically to this scenario in this case, and what circuits have reasoned, including this court, is that actual contact needs to be made by a bullet or the actual hands of the officer, Your Honor. The district court here attempts to narrow the scope of what a Fourth Amendment seizure entails and incorrectly defines a seizure to require acquisition of physical control. However, physical control is not a requirement this court and other circuits have adopted to establish a seizure, Your Honors. And to my second point, there is clear evidence that officers Henderson and Jordan intended to seize Jackson when they instructed him to stop and fired 13 bullets at him. And Your Honors, intent is the second element required under Hadari D, and that is met here. As reflected on page 4 of the record, the officers instructed Jackson to stop and get out of the car, and they proceeded to fire bullets at him. This evidences the intent required for a Fourth Amendment seizure, Your Honors. Contrary to petitioner's contention that immediate cessation of movement is required, this court has held that for a Fourth Amendment seizure, if the law enforcement officer applies intentional physical force in a manner to control the pursued suspect, it's considered a Fourth Amendment seizure, and submission to authority and cessation of movement is irrelevant, Your Honors. And
counsel, this kind of ties a little bit back into the earlier questions I had and a question you gave about the intent to, and it ties in now to the intent to seize. You'd made mention that the officers, if they felt he was a true danger, could have ceased firing and actually initiated a pursuit. Is there any evidence that they did that, or did they just fire upon this individual, and then as he drove off, they went back to what they were actually doing, the raid at the suspect? Wasn't it a raid at a suspected drug house or something like that? Did they actually pursue or attempt to pursue Mr. Jackson as he fled the scene?
No, Your Honor. As reflected on page 4 of the record, the officers did not attempt to pursue him after. They just kept shooting, and they were able to apprehend Jackson at the hospital the next day, Your Honor. And it is for the above mentioned reasons this court should affirm the 14th Circuit's ruling, because officers Henderson and Jordan seized Jackson by shooting him not once, but twice. If this court were to rule in favor of Officer Henderson and Jordan, it would not only ignore this court's established precedent, it would also promote a shoot first, think later mentality that this court sought to avoid in Hadari D. Thank you, Your Honors.
Thank you, counsel. Cheryl, what do we do now? Cheryl?
You're still muted, Professor Anderson.
Oh, we got rebuttal, don't we?
Yes, we have rebuttal.
Oh, I forgot about that. Okay.
Good.
Rebuttal.
Your
What?
Honors, just 2
minutes.
minutes.
Did you reserve 2 minutes?
Yes, Your Honor.
Okay. You may proceed.
Thank you, Your Honor. Just 2 quick points on rebuttal. Contrary to what the respondent has asserted, this is not a major intrusion into the liberty interests of motorists. This is a brief investigatory stop to determine the identity of a driver. The Fourth Amendment only prohibits unreasonable searches and seizures, not any search or seizure. Here, it is reasonable in the interest of keeping possibly dangerous people off the roadways to make these brief stops. Second, turning to the seizure issue, Your Honors, this was not a seizure even under the alleged expansion of Brower in Hadari D. While Hadari suggests that a seizure occurs whenever someone is restrained briefly, the facts of this case indicate that the respondent was not restrained even for a moment. After being hit, he drove off, stole a car to avoid contact with the police, as is reflected on the record of page 4, footnote 8, and then drove 60 miles. He was simply not stopped after being shot for any amount of time because he kept driving away. Therefore, we respectfully ask that this court
But counsel, real quick on that second point on the seizure, kind of getting back to my last question for your the last question that I asked respondents, counsel, isn't it? It's a little troubling to me that the officers felt potentially lethal force of shooting at Mr. Jackson as he fled in his vehicle was appropriate, but we don't seem to have any information in the facts that they effectuated a pursuit. I mean, he was able to, he got away, yes, but did we have nothing that says that they jumped in their patrol vehicle and attempted to apprehend him in a pursuit prior to him carjacking somebody else and ultimately fleeing 60 miles away? Where there's a little bit of a disconnect there, that there's an argument that by the state that this was justifiable force by the officers, who at the same time let this guy speed out of an apartment complex with reckless abandon. And you can briefly answer my question.
Thank you, Your Honor. Your Honor, we should defer to while there are no facts reflected in the record regarding the subsequent actions of the petitioners Henderson and Jordan, we should defer to their training and reasonable judgment that maybe a high-speed pursuit through a municipal area may be more dangerous than firing those initial shots at the respondent. And Your Honor, the question before this court is not the reasonableness of the actions of the officers, but whether their actions alone simply constituted a seizure under the Fourth Amendment. And that is how we should look at this issue. Thank you, Your Honors.
Thank you, counsel.
And with that, the matter would be submitted to the court. And I'm also going to stop the live stream by first thanking our judges and our advocates. We had a good chat going on our live on our YouTube channel. And so we thank you guys very much for participating. So at this point, I'm going to end the live stream.